All right, let's dive into a case that is, and I mean this, an absolute giant in international environmental law, the Trail Smelter Arbitration. This was a showdown between the United States and Canada that went way beyond just a local pollution issue. It literally set the stage for how countries have to deal with each other on environmental problems even to this day. So let's get into it. And just to give you an idea of how big a deal this is, we're not talking about some obscure historical dispute. This case is so important that it's published in the United Nations official reports of international arbitral awards. That tells you right away that its impact is global. For anyone studying this field, especially for exams, you absolutely have to know Trail Smelter inside and out. It's a cornerstone. So here's our game plan. First, we'll look at the facts on the ground, what was actually happening with the fumes. Then we'll follow the paper trail that led to arbitration. We're going to break down the 4 huge questions the tribunal had to answer, look at their first big decision in 1938, see how they created a permanent fix, and then the grand finale, the landmark legal principle that changed everything. Okay, let's set the scene. Before you can even begin to understand the legal back and forth, you've got to understand the geography and the industry that sparked this whole thing. So picture this. There's this enormous smelter up in Trail, British Columbia, run by a big Canadian company. The key thing here is its location. It's sitting in the Columbia River Valley, only 7 miles north of the U.S. border. Now, that valley isn't just a pretty landscape. It acts like a natural chimney, a funnel, sucking those emissions and channeling them straight south, right across the border into Washington state. And the problem really blew up in the mid-1920s. The smelter expanded, built bigger smokestacks, and, well, look at the results. The sulfur emissions basically doubled in 10 years. By 1930, we're talking about 10,000 tons of sulfur every single month. That's something like 300 to 350 tons of the stuff pouring into the atmosphere every single day. And you better believe people noticed. This wasn't just an invisible gas. These sulfur dioxide fumes were doing real, visible, devastating damage. Starting around 1925, farmers in Washington saw their trees dying, their crops withering on the vine, and their property values just tanking. This wasn't just pollution. It was a full-blown economic and environmental crisis. So you have a bunch of angry farmers on one side of a border and a huge factory on the other. How does that become a major international legal case? Well, the road to arbitration here is a perfect lesson in how international disputes get resolved. It started small with individual complaints back in 26. But by 1928, it was big enough for the US and Canada to get the International Joint Commission involved. The IJC looked into it and, yep, in 1931 they confirmed damage was happening. But the pollution kept coming. 2 years later, the US was still sending notes saying this was entirely unsatisfactory. They realized a simple report wasn't going to cut it. So they took the next massive step. In 1935, they signed the Convention of Ottawa, creating a special arbitral tribunal that could make a final decision that both sides had to follow. Now, that 1931 IJC report did have some teeth. It suggested Canada pay $350,000 for all the damage done before 1932. And as a sign of good faith, Canada agreed to pay up. Think of it like this. They settled the old bill. This cleared the deck so the new tribunal could focus on the fresh damage happening from 1932 onwards. Okay, now we get to the real legal heart of the matter. The convention didn't just say, hey, tribunal, figure this out. It gave them a very specific to-do list, a clear mandate spelled out in 4 crucial questions. And these 4 questions, right from Article 3, were everything. Question 1 looked backwards. Did more damage happen after 1932? And if so, what's the bill? But then questions 2 and 3 pivoted to the future. Should the smelter be ordered to stop? And what practical technical system, what they called a regime, should be put in place? And question 4 was a fascinating little safety valve. If this new system hurt the smelter's profits, should the company get paid for that? It was a brilliant attempt to balance protecting the environment with protecting the economy. So what rulebook were they supposed to use? This clause from Article 4 is critical, especially for a law student. It told the tribunal to look in 2 places. First, U.S. domestic law on similar stuff, think pollution cases between 2 states, and second, existing international law. They were basically told to blend these 2 legal worlds together to create a fair solution. So the tribunal had its marching orders, they rolled up their sleeves, and in 1938 they came out with their first major ruling. This one was all about answering that first question, tallying up the damages. After digging through mountains of evidence, we're talking soil samples, crop records, expert reports, the tribunal's answer was a slam dunk. Yes, without a doubt, the Trail smelter had continued to cause damage in Washington after the 1932 cutoff. So with that settled, it was time to answer the next part. What's the price tag? The number they landed on was $78,000. That was the final bill for all damages over a period of almost 6 years. But, in law, the number is only half the story. The really interesting part is how they got there. So the tribunal went through the U.S. claims with a fine-toothed comb. That whole $78,000, that was purely for the damage to the land itself, basically its reduced value. Claims for dead livestock? Denied. The tribunal said that was already covered by the land's loss of value. Property damage in town? Denied. Not enough proof. And this is a big one. A claim for violation of sovereignty to cover the U.S.'s investigation costs? Also denied. The tribunal said that wasn't what the convention was for. Let's zero in on those business claims, because this is classic legal reasoning. The U.S. argued that businesses were hurting because the local farmers were broke and couldn't spend money. But the tribunals said no. The connection was too indirect, remote, and uncertain. If you've ever studied tort law, that language should sound really familiar. It's all about proximate cause. They drew a line in the sand. For an international claim to succeed, the injury has to be a direct result of the act. Okay, so the past was settled, but the tribunal's most important and, frankly, most creative work was still ahead. They had to figure out how to stop this from ever happening again. And here is where the tribunal showed some real genius. Instead of just making up some rules or taking a wild guess, they straight up admitted, we don't have enough good science to make a final decision right now. They knew the science of how pollution travels was new, and they needed way more information to do this right. So what did they do? They came up with a temporary experimental plan. It was brilliant. They set up a trial period for more than 2 years. They brought in technical experts to run the show. They ordered the smelter to hire a meteorologist and set up observation posts to track everything. They essentially turned the whole region into a giant living science lab to figure out exactly how the pollution behaved. The science would dictate the legal solution. And you know what? It worked. By 1941, they had the data they needed and established a permanent set of rules for the smelter based on hard science. But the case's real legacy, the reason we're still talking about it today, isn't just its clever method. It's the powerful legal principle it carved into the stone of international law. And here it is. This is the sentence you highlight, you underline, you commit to memory. The Trail smelter case established that no country has the right to use its territory in a way that causes serious harm to the territory of another country. This idea, this principle of state responsibility for transboundary harm, became the absolute foundation of all modern international environmental law. So let's just quickly recap its incredible legacy. 1, it cemented state responsibility for cross-border pollution. 2, it pioneered a science-first approach that's still a model for solving these kinds of disputes. 3, it created a blueprint for how to handle environmental arbitration. And 4, because of all that, it's a foundational case that gets cited constantly in major environmental treaties and declarations. Which brings us to one last thought. Back in the 1930s, the fumes from one single factory forced the world to answer a huge question about responsibility. Today, we're facing challenges like climate change, where the pollution from all nations creates one giant global problem. The core idea from Trail Smelter is more vital than ever. The real question for us now is, how do you apply a principle born from one smokestack to a problem that involves the entire planet?